All right, we're live.
Hi everyone, thanks for joining our live stream. We're going to be talking about how to know when you have a strong EB-1A profile. And it's a complicated question because I think you can always do more, you can always build more, you can always make a stronger profile. You do have to determine at a certain point in time though when you're going to file, like when enough is enough, when you feel that you have a strong enough argument to put in front of USCIS and hopefully get the approval. For all of you, the key thing is having at least 3 strong criteria. So 3 criteria at least where you are somewhat confident that USCIS will accept the argument. They should all be strong. Nothing is going to be above questioning. I will say I've gotten RFEs on so many criteria that I thought were airtight or solid or like beyond questioning. USCIS can always find a way to question them. But when I say strong criteria, I mean most people would immediately assume that this was qualified, that it was strong enough, and that your case should proceed forward. So you need the core 3. You can have a bunch of others as well. So often I do file cases where we're doing 5 or 6. I have done some where we've done 7 or 8, although that's really rare. If you end up submitting a case with 3 or 4 really strong criteria and then 1 or 2 weaker but viable criteria, that's a good case. After determining whether or not you have 3 strong criteria, you also need to determine if you have a good final merits argument. And this is sometimes additional evidence or documentation, but most of the time it's just putting together a narrative for what's already on the file and demonstrating to USCIS why you have risen to the top of your field. Most of the time this flows from an anchor criterion, so usually something like critical or leading role or original contributions. But you should be able to tell USCIS really succinctly and directly why you are at the top of your field. If you can do those things, if you have the 3 strong criteria and a good argument or a claim that you're at the top of your field, you have a strong case and you can proceed forward with confidence. If you have those things already, additional profile building might have some diminishing returns. Like, of course, every additional element adds to the profile. It might make the profile stronger, but the more activities that you add, the less value each additional one has compared to the one before. So you might add 10 additional judge roles, but they're not meaningfully impacting your chance of approval. So at a certain point, you just have to decide, my case is strong enough, I'm going to proceed forward and I'm going to file it. I might continue to do a few profile building activities in case it's questioned and in case I need to present additional evidence. But once you have the 3 strong criteria and a claim for why you're at the top of your field, you can proceed forward. Now, I think the question is, how do you know if you have 3 strong criteria, given that USCIS can question these criteria from all different angles? And that is something that you should talk through with an attorney. So someone who is experienced in filing a lot of EB-1A petitions and can tell you what the angles for questioning might be and what you can do to present the argument in a strong way. Well, I guess we can get into some criteria examples later on. I did want to focus it in on the high level. We can start to open it up for questions, though. So if you have questions, especially about the high level stuff, especially about how to make the decision on whether or not to file, whether or not you have a strong profile, go ahead and start posting those, because those will help lead our discussion and conversation here. While you're doing that, we can dive into an example of how a specific criterion can work. So take, for example, a really popular one. We'll do judge of the work of others. How do you know if it's strong enough where it's ready to claim? First you have to have actual judge roles that have been done, completed, and you've actually completed the whole assignment. You can't be in the process of judging things. You can't have an invitation for a future event. You have to have actually judged the thing. So that's number 1. Number 2, you want to know that some of those activities are activities that are readily accepted by USCIS. And the best way to do that, I think, is to go to the policy manual and see what kinds of activities are described there. Policy manual is not a comprehensive list, so it's not like your activities have to match the ones that are there. But if they do match, you at least know that USCIS is supposed to accept them, and that would be good. So, for example, if you've done peer review of 2 journal articles, you know that USCIS will accept those as judge role. Now, having 2 is not very impressive, but the criteria will be checked off the list for you. So you don't need to do more. If you do more, I would recommend targeting a couple different categories of judge roles. So maybe you did some peer review for one conference. You should also do some peer review for either a journal or for a different type of conference. And then you should look at other activities as well that can expand the profile here. So you could choose to judge awards or competitions, just to add some more dimension to the profile. I really like when you specifically and individually have been invited to review programs, policy proposals, designs, something by other organizations or by other top experts in the field, because it demonstrates that you are being specifically sought after for your expertise. So adding some of those elements into the judge role are really, really good too. Those aren't necessarily mentioned in the policy manual, but you already have the activities that you know qualify according to the policy manual. So this is really the kind of activity that is good, and it flows to final merits because you have been individually recognized. So putting everything together, you have a few different types of activities. At least some of them are specifically accepted in the policy manual. At least some of them flow to final merit, showing that you are being recognized as being a top expert in your field. And once you have a few of these activities, you're good. It's not about volume, so you don't need 100 judging activities to qualify. Some law firms, some companies, some other entities, they have benchmarks. I have talked with a client before who said they wouldn't take her case unless she had 200 instances of judging, which is really crazy to me. I've maybe submitted less than 5 cases total in my entire career that had that many judging activities. So for me, it's not about benchmarks. It's just about putting everything together, knowing that some of your activities will definitely be accepted, some of them flow to final merits, and putting everything together, that's a strong criteria. So even if you only end up having 5, 2 peer reviews for a conference, 1 peer review for a journal, 1 awards ceremony, and then 1 instance where you were called in by an organization to review something about best practices or some technical guide or so on and so forth. That's a really strong lineup, even with only 5 activities done. All right, hopefully that was a good example. So that's kind of how I look at the criteria to know if criteria is strong. I've talked in other videos about final merits as well and the anchor criteria. We can definitely go into more detail if people have questions. But yeah, Jason, do you see anything come up with regard to this, and any particular question that is on trend right now?
So a lot of people are going for media coverage, and spoke to someone recently, and he said that a lawyer he was speaking to said he didn't have a strong case because he didn't have media coverage, even though he has a strong leading or critical role claim and high salary, a lot of judging. That's what he was told. So is media coverage really necessary for a strong profile?
No. Most EB-1As that I submit do not include the media criteria. The vast majority do not have that criteria. I do like to include it. I do think that getting some quotes in the media, getting a couple profiles in the media can be very powerful. It's good recognition of your expertise. If it's done correctly. There are definitely profiles and publications out there that are clearly just self-promotional, and that has pretty low value for the EB-1A case. So I wouldn't necessarily recommend those kinds of media coverage. But if you get quoted in a couple of articles where the reporter is reporting on something relevant to your field and you're being quoted as an expert, it does look really, really good. Now, does it qualify for the media criterion? Maybe not, because the media criterion requires that it be about you and your work. Usually just a simple quote won't cut it. But it does flow to final merits, and it does add legitimacy to the case. So don't fully discount media. I do actually encourage people who are profile building to add it to one of the lists, one of the criteria that they are that they're actively pursuing. But yeah, it's not a requirement by any means. I work with a lot of people who are profile building and trying to get media and then never do, and they still come up with really strong cases.
How about awards? It's another criterion that a lot of people try to claim. That's why you have all these generic awards out there.
Yeah, awards is also something I claim very rarely. I would say I claim media more than I claim awards. The awards category works really well for performing artists, for athletes, other artists, sometimes for business executives. But it's not a great fit in tech. There's not a lot of really prestigious awards in tech that are out there. And the US government doesn't really do like national level awards like some other countries do. So awards have really limited value, especially in industry or tech cases. There are some organizations that have popped up to do this kind of recognition. So you have the Stevies and the Globies, you have the Codys and the Nobles and the Titans and all of these. Sometimes if you win a top level award in one of these groups, maybe we can claim it. But the problem with a lot of these awards organizations is they're trying to gain momentum, but they haven't yet gained that recognition for themselves. Like they're not being recognized in third-party media. They're not necessarily being highly sought after by companies or by individuals at the top of their field. They are a little bit more, I guess, fluffy is the word. It's nice to have that kind of recognition and that kind of award, but it's not going to be super persuasive to USCIS when they're sitting down to say, okay, is this a nationally or internationally recognized award in the field? The answer is usually no for most of those. So I wouldn't go for awards as profile building for most industry or tech cases. I would only go for them if it has real meaning in your field. So like artists who are entering certain competitions, I definitely recommend doing the competitions and actually going through that process because those awards can be really prestigious. But yeah, not for tech.
Do you have to claim the high salary criterion?
No, and I routinely do not claim it. Like it's really nice if you can combine critical and leading role with high salary because they kind of reinforce each other and they can form the core of a really strong case. But I work with a lot of people who have done some really interesting and technically excellent things, who are just never going to earn a high salary because it's not really philanthropic work, but it is more public interest type work where those positions are just not highly paid and never will be. They would have to kind of sell out and go to a big tech company in order to get that high salary. And most of them don't want to do that because that's just not what they're doing. That's not how they're contributing to the world.
So if you work in a role that typically provides a salary that meets the high salary criterion, if you can't meet the high salary criterion, will that get flagged by USCIS?
Not flagged, but it is something that they might notice. Like if you are a software engineer at Google and you're not claiming high salary, it's not like they're going to point that out, but it might factor into some degree if you're claiming critical or leading role for Google. Yeah, so I've never seen it explicitly questioned, but I do think that it can impact the adjudicator's mindset when looking at the petition.
And original contributions is not necessary. And how about a lot of people are getting questioned now on sustained a claim. Like people are asking me how they can avoid that kind of questioning.
It's all narrative. So if you're presenting a compelling narrative where USCIS gets to the end of the criteria and is already convinced that they should approve your case, that's the best way to avoid it. There's not a formula for it though. Like USCIS they can question sustained claim on every case. They're actually supposed to with the two-prong analysis, first the criteria analysis and then final merits. They're supposed to question sustained a claim on final merits. And I think a lot of officers are really frustrated with some of the cases that they're seeing come through right now because the cases are not traditionally strong. They do meet 3 criteria for sure, because a lot of people have done a really good job in building their profile so that it does meet the EB-1A criteria. But they are looking for ways to kind of stem the tide, slow things down, deny cases that they wouldn't typically approve. And doing sustained a claim is the way to do that. There are some lawsuits going on right now that are trying to get the courts to stop the 2-prong analysis. And I think it's very interesting. Before we had Kazarian, the government's approach to EB-1A was to look at the criteria, and then they wouldn't ask the petitioner to prove final merits. They would just do a final check, and if they really thought the person wasn't extraordinary, they would be able to deny the case based on derogatory or negative indications that go against their extraordinary ability. The Kazarian decision flipped that and created this kind of standard where it created a new burden on the petitioner to affirmatively prove that they had final merits, that they had risen to the top of the field, and so on and so forth. And the litigation is saying that that's an impermissible change in the law that needed to be promulgated through notice and comment rulemaking. It wasn't appropriate to put that into place as the legal standard for these cases. And I think it's a pretty persuasive argument. I really hope that some of these cases get approved, or not approved. It's not the right word for litigation. I hope that they go through and get the courts to agree, because that could really change the game for EB-1As. So many of the issues though just stem from the fact that we have a quota system, right? We wouldn't have so many issues with USCIS officers thinking that people are trying to game the system if we didn't have a system set up that required gaming. The quota system, the preference category system, remember all of it was created, more or less created in the 1950s and then revised a few times since then. But the last revision was done in the early 90s, I think 1991. And so the implications that we're seeing today are not necessarily what was ever intended for the system. And it's all gone a little bit crazy. If Congress would just update the law and pass a new law, we would all be fine. And eventually they're going to have to, because the EB2 category for Indian nationals is well over 100 years at this point in time. It's not going to be 100 years for 100 years. Eventually the law will change, and I just think that we're far overdue for that. I wouldn't expect it, though, under the current Congress. That's for sure.
So I don't see any questions. Anything else you want to cover?
No, that's good for this live stream. Thank you, everyone, for joining. Hope this was helpful. And remember, revisit this with professionals. Like, talk to an attorney if you are wondering if your case is strong enough, because you can get some pointers, and then you can decide for yourself what your timeline will be for profile building and filing. You should just go into it with open eyes and know if the profile is strong enough for your own comfort with risk factors and risk of denial.
Great.
All right.
Thanks, everyone.
Thank you.